Hello friends, in the series on the income tax cases, today we will discuss a very important case of the Madras High Court in the case of Tamil Nadu State Marketing Corporation Limited versus Deputy Commissioner of Income Tax TDS, which has been reported in 463 ITR at page number 487. The date of the judgment is 22nd December 2023. In the present case, a very limited issue was before the Honorable Madras High Court. The issue was that if a company which is owned by the state government, who is having monopoly over sale of liquor in the state, and if the company is granting the license to the various bar owners for the sale of liquor, and after the consumption of liquor, the company is also collecting the empty liquor bottles from the various bar owners. So whether this collection of empty liquor bottles will come into the definition of scrap and consequently sale of scrap, the learned assessing officer during the proceedings held that the bottles come into the definition of the scrap, and hence the provisions of section 206C are attracted and held the assessee as assessee in default. When this matter travelled to the Madras High Court, the Madras High Court said that in the present case, depending on the facts and circumstances of the case, the collection of empty liquor bottles cannot be treated as a scrap for the attraction of provisions of section 206C. The court said that scrap has been defined to mean waste and scrap from the manufacture or mechanical working of materials. So the question before the court was that whether in this case the empty bottles come into the definition of the scrap or not. When the court analyzed the case, the court said that in the present case, the bottles are open in the bar. The bottles are not opened by the assessee, and when these bottles are opened, the process of opening the bottle is like taking out the cork from the mouth of the bottle, or taking the cap of the bottle, and whether this taking out the cork from the bottle, wine bottle or the liquor bottle, or the opening of the cap, whether this process can be termed as manufacture or not. So the court said that in the present case, even in the remote sense, this does not come into the definition of manufacture. The court further said that since the second limb of scrap is mechanical working of materials, so the mechanical working of materials has not been defined in the act. So the mechanical working of material will take the color of its definition from the definition of the manufacture. So the court was of the considered view that in the present case, since these bottles are not opened at the premises of the assessee, these are collected from the premises of the various bar owners where these bottles are consumed, where this wine is consumed, where this liquor is consumed, and so even directly or indirectly opening of the bottle does not come into the definition of manufacture or mechanical working of materials. So when it does not come into the definition of the manufacture or mechanical working of materials, so it does not generate scrap or waste which can be termed as scrap according to the definition of section 206C. So friends, in the present case, the assessment or the proceedings were related to the assessment year 16-17 to assessment year 23-24. So by a consolidated order, the Madras High Court gave relief to the assessee that in the present case, the assessee is not liable to collect TCS on the sale of scrap, that is empty liquor bottles, and gave the decision in favor of the assessee. At the end of this video, Once again, I am repeating the name of the case. The name of the case is Tamil Nadu State Marketing Corporation Limited versus Deputy Commissioner of Income Tax TDS, and this case has been reported in 463 ITR at page number 487, and the date of the judgment is 22nd December 2023. Thank you, friends.